The topic assigned to me and to the panel is state aid, a closer look at at subsidies as one form of state intervention. What do I propose to do? I'll say a few words on the rationale behind subsidy control, something that we have already discussed yesterday. And I have mentioned that I have a slightly different view. I think that subsidy control has a very narrow scope of application in specific situations. I'll come to that in a second. I will very briefly talk about the WTO and EU regimes in general. Try to compare them and especially point out their flaws. I'll try not to bore you because I trust most of you are familiar with the state aid prohibitions. And then I will come to the center of the presentation, which is the question whether state aid control is working. So do we catch the state-initiated restraints of competition that we want to catch under under the tests as they're set up in the WTO and EU regimes? And I will also not spare you some conclusions. You will probably have noticed or not, I think there is no handout, that I have a lot of slides, but don't worry, I will skip over most of them, and I also have an arrangement with the chair that he will politely stop me if I am too long. I didn't bring a watch. So do we have subsidies is the first question. Of course we have subsidies, and as this reference to Adam Smith, The Wealth of Nations, something that we've already seen on the slides yesterday. It's a book that is frequently cited. It's always nice to open a presentation with that. There is a chapter on bounties in that book, so subsidies are a very old chapter. And the reason for that is that subsidies, of course, are an issue of state policy. The state is free to hand out subsidies as a matter of policy choice. So, of course, we do have subsidies. The question that flows from that is, do we want subsidies? Is it good to have subsidies? I will not speak about this today because I think that's for the economists to answer, really. Whether a subsidy is misplaced in a specific situation is something that depends on, I think, an economic assessment, something that also the Commission has tried to introduce in state aid control in the recent years under the more economic approach, first in antitrust, and it's slowly also reached state aid. So I will not either speak about the question, do we want subsidies? What I will speak about is, shall we control subsidies? And this is where I enter my presentation. That's a legal question. I think the legal question can be addressed, and the question is, under what circumstances should we control subsidies? And here to start, I think a distinction has to be made between national subsidy situations and international subsidy situations, and that alludes precisely to the discussion that we had yesterday. I think on the national level, the mechanisms that are in control, and you see that up on the slide, that are in place to control subsidies are general mechanisms of non-discrimination, fundamental rights, the need for a legal basis, fiscal restraints, all sorts of restraints. I've mentioned Article 106, so that's a specific non-discrimination norm for enterprises that are public vis-a-vis private enterprises. So there are a lot of mechanisms in the general framework, I think, of a national state or an intrastate setting that can be utilized for subsidy control, although they're not subsidy control proper. So if we speak about subsidies or the kind of subsidy control that I have in mind is an international setting. And why, where do I take this from? I think there are only two evolved regimes for the control of the competitive effects of subsidies, and that's the WTO and the EU regimes. And both are regimes that concern transnational market integration, although to different, at different levels. I think it's precisely this in-between situation of transnational market integration where you need subsidy control. If you have a lesser or a higher state of market integration, you do not need subsidy control. Why? Because if you have a higher state of integration, obviously the intra-state mechanisms will apply. I put up here the example of the US, but probably, maybe you will disagree, but I think maybe also in China you would have a situation like this. How does the US control subsidies? By inter alia, and I speak under the control of the US lawyers in the audience, by use of the Commerce Clause, so the relevant competencies for, or some of the relevant competencies for controlling subsidies are a federal competence. They're not in the state competence. If you have a lesser state of integration like NAFTA, ASEAN, or Mercosur, the national borders between the markets exist still to an extent that the competitive effects flowing from those national borders are much more important than the subsidies. So the borders are the more important problem compared to subsidy control, which means that you do not need subsidy control. There are other mechanisms that are of a tariffary nature in part, sometimes also restricted only to certain sectors. For example, NAFTA controls subsidies only in agriculture. A very common clause is also the prohibition of drawback. I'll not go into this. Just leave you with the statement that if you have a lesser form of integration than the WTO and the EU propose, you will not need subsidy control. Excuse me. With that, I'll venture into a brief overview of the WTO regimes. The main legal basis for subsidy control in the WTO regime, as I'm sure you know, is the SCM agreement. That agreement defines subsidies by 5+2 characteristics. The first 5 are cumulative. The second set, so 6 and 7, are alternative. That is, so a subsidy is a financial contribution by any public body involving a benefit for an enterprise in a selective manner. That is either related to import or export or involves another form of economic injury and serious prejudice. As you will see in a second, those elements of the subsidy definition are very similar to what the EU has laid down. And of course, up there figures the topic of our conference, the financial contribution by the public body. Just a word on probably enforcement. Enforcement under the WTO regimes is very weak. It's basically modeled after international law, and that's a major difference to EU law, where I'm sure you're familiar. Enforcement is very effective. Subsidy control is part of individual rights that you can take before a national court to enforce. And that has an important leveraging effect in terms of the flaws of those regimes, because of course if you can enforce a regime that is flawed, the effects of those flaws will be even graver than if you have only a weak enforcement regime in place. So in comparison to the WTO regime, the EU regime under the Treaty of the Functioning of the European Union, it's a matter of taste how you group those constitutive elements for a state aid definition. I've taken out 5. They're all cumulative. It's a selective advantage, so it has to be a specific advantage, not an advantage that your economy gets on the whole, to an undertaking granted by the state, of course. So that's, again, the topic of the conference. And that results in a distortion of competition or an effect on trade. The underlying question, which I will, however, not deal with here, is who is the state? Suffice it to say here that both the WTO and the EU regimes apply a very broad notion of the state, so it's bodies vested with sovereign power, as well as other bodies that are entrusted, other entities that are entrusted by the state to fulfill functions that are used as tools to verse the aid, but that's a separate topic that I'll not go into. Just another word on a slight comparison between the EU and WTO regimes, but really just very briefly. They have a divergent background, but you see that the elements of the definition are similar. I've told you that the enforcement setting is different, and that has an implication on the relevance of the flaws that we find in there. But if you look at the definition of the constitutive elements of the state of the subsidy, the term subsidy, the regimes differ quite a lot, and this is what I will speak or devote the remainder of my presentation to, because of course this is where the flaws are vested. So I will talk about the definition of the state element in subsidies. So not the question, the precursor question, who is the state, but just the question is the definition of the state as we have it in the scope of the norms correct. So, is state aid control working? Does it deliver a level playing field? I would suggest that if it delivers a level playing field between the undertakings of different national markets, so in a transnational setting, if it shields the undertakings from state intervention with financial means, state aid control does work. I think there are some loopholes in both the WTO and the EU definition that disallow state aid control to work under both regimes. The main reason under the WTO regime is that it follows a formal approach. What is the formal approach? The definition of what is a state measure is a financial contribution by public or entrusted body, so a broad definition of the state, but then coupled with an exhaustive enumeration of, specific measures that are caught by the prohibition. And of course, whenever you have an exhaustive enumeration of forms of measures, there is a risk of gaps. In particular, complex forms of regulatory intervention may escape subsidy control. I give an example here, feed-in tariffs, so that's a financing obligation that is laid down in law for private parties to subsidize specific methods of production of energy. That is something that you will probably not be able to control under the WTO regime, but maybe that's fine because it doesn't, for the specific setting that the WTO is set up, maybe it doesn't play a role. But if you look at the EU regime, the gap is similar, although the EU regime follows a different approach. It's not a formalistic approach. It is, along with EU law in general, a functional approach. And I put up here a definition taken from the Court of Justice, European Court of Justice, in one of the state aid cases, but that is consistent jurisprudence. The Court of Justice, and following the Court of Justice, of course, the European institutions in enforcing state aid, so that is the Commission, follow a double or employ a double condition for state aid. A subsidy or an aid is only then attributed to the state and not to a private party. So it is only then prohibited if the state finances the measure and has taken the initiative. So both elements have to be fulfilled in order for the measure to be caught. In typical or classical situations of state aid, very often financing and initiative will coincide. So if a ministry hands out a direct grant to restructure an undertaking, of course the initiative and the means come from the public budget. But as I said, for the WTO regime, also under the EU regime, more complex measures of utilizing third parties for the grant of aid may escape the regime. And what I find striking is that although it is not a formal approach that the EU employs, it's a functional approach that looks at the functioning of the measure, that approach is flawed. So what you see on this slide is basically in the lower part, what are the situations that are problematic. The use of public undertakings, the use of private undertakings, and maybe also the use of consumers. I will not speak about the latter two parts. That's, again, a specific setting. We can discuss that if you care afterwards. But specifically, the use of public undertakings for the implementation of aid is something that in some constellations you cannot catch. Why? Because the double condition means, or the double condition of state attribution of a measure essentially amounts to checking who is in control of the decision to grant the aid and the resources used to finance the aid. The decision to grant the aid is often very easily checked. You have a law, you have a ministerial decree. There are complex situations sometimes of informal influence on a public undertaking, but because the Commission and the ECJ employ a very low threshold test that is essentially based on circumstantial evidence, those situations, so the initiative is very often easily attributed to the to a public body. So even if an undertaking is influenced, say, a local airport by the local government to hand out a specific subsidy, the initiative is not the problem. What is a problem is the control over the means used to finance the aid here. The test is, can the state actually use the resources? Can the state direct the use of the resources? Again, in principle, the test looks like it was low threshold, so indirect control would be sufficient. What is indirect control? For example, control through a public undertaking, so the means that a public undertaking has are always public means, because eventually, at the end of the day, the entity that decides about the use of the means, depending, again, on the underlying corporation or articles of incorporation, but very often those means will be directed indirectly by the state. So this is something that you have up here. Only where the state is not in a position to direct the use of the resources, for example, if a professional body is set up under or backed up by law, so it's set up under a national law, but it is totally independent in terms of the initiatives it takes and the use of its resources. For example, the fees that the members pay, take Ascola, for example, this would not be caught by the state aid prohibition. So, to stop all the confusion, that was all a precursor, but don't worry, I won't be too long anymore. How or what is now the loophole that I detect even in the functional approach of the EU? How can the state initiate a subsidy without being caught by the state aid prohibition? Very easy. You take the initiative, or a state takes the initiative to grant the aid, but it does not assume control over resources. And how do you do this? You create a financing obligation in the law without further intervention of the state. This is the classic area of parafiscal charges, and in fact, in the famous, not very recent anymore, Preußen-Electra case, the ECJ has backed up this approach. The ECJ has said the creation of a legal obligation alone is not enough. So the creation of a legal obligation by the state alone is not enough to bring a system of subsidies within the within the state aid prohibition under Article 107. Why did the ECJ say that? Because essentially, although Preußen-Electra was a case of feed-in tariffs on an electricity case, but essentially I think what the ECJ tried to protect is minimum price systems. Imagine a system of a minimum price for alcohol, depending on whether consumers are locked in or not, but I think the ECJ didn't go into that detail. But essentially, if you have a minimum price system and the market share does not go down if the price goes up, you could argue that you have aid for that sector. And I think, and there are some other cases, Van Tigele and so forth, that the ECJ tried to shield this legitimate area of minimum pricing from the scope of application of the state aid prohibition. However, the problems created by this approach are manifold. I will jump over the, I won't jump over the examples. I give you the examples maybe to make this a little more illustrative. So if you have a minimum price, like I just mentioned, that will not be a state aid system. But also, for example, if you try to, or the state tries to subsidize a certain method of production of electricity or a certain sector, and it does it in a way to create a surcharge on the product that is produced, without intervening in the distribution of that surcharge to the sector that benefits from the aid. Also, such mechanisms, for example, production of green electricity, CHP, and so forth, will not be caught. But as soon as you bring in a public body, so for example, the surcharge goes to a ministry, it's not paid directly between customer, producer, supplier, but you bring in a ministry that distributes the surcharge. The ECJ says, okay, now we have public involvement, and the same system with the same aims is now aid. I wonder, does this make sense? I give you some examples here, but just don't worry. I'll quickly surf through them. So we've talked about green electricity. This is a very recent, the German case is not recent, the Austrian case is more recent, where this distinction figured. The German CHP, so that is combined heat power generation, a specific environmentally friendly form of energy production, under the German system was considered to not involve aid, although the declared aim was to subsidize CHP production. And the reason was because there was no public ministry involved in the distribution of the means, whereas the Austrian CHP system, which was the same in terms of aims, it was similar as regards to types of subsidies, but the means were distributed via a public body. That system was caught by the state aid prohibition. I wonder, what about the level playing field? Another example, and these are just two, but especially in the area of energy production, there are more. Another example of this is the area of certificate trading, where the Commission and the ECJ introduce a distinction along the lines of what does the certificate certify? Does it certify the product, or is it a tradable asset by itself? What do I mean by this? The Belgian system that was held not to involve state resources was a system where producers of energy with combined heat power production could trade the amounts of energy under the CHP production system among themselves in order to reach a certain quota that the state had prescribed. If the supplier of energy did not reach that quota, sanctions applied. So to avoid the sanction, you didn't have enough CHP energy, you could buy it from someone else. Commission said that's an entirely private system, although of course all the obligations flow from a state law. We do not touch it under the state aid prohibition. Very similar, a Dutch emission trading scheme. That's a more recent case. Very similar in terms of the sanctioning mechanisms. So industries were required to keep their emissions low. They had a certain amount of emissions, as you know. I mean, that's an international system. A certain amount of emissions that is allowed. If you exceed those emissions or emission rights, sanctions apply. And what the Dutch said is, yes, we implement this system, but the emission trading rights that you have not used are tradable. So if you remain under your quota, you can sell off what you have not used. Court of Justice has said, okay, this is also a certificate scheme, but it does involve state resources. Why? Simply because of the fact that the emission trading scheme, the certificates in that scheme are an asset by themselves. They're not attached to the product, and we treat this system differently. We treat this system as being a state system differently from the Belgium system, which was considered a private system. Again, the question, does this make sense, or are not very comparable situations in terms of competitive effects treated differently? I would suggest yes. And that's also why, as a precursor to my conclusions, I think the EU and the WTO, in spite of taking or coming from different ends in terms of definition of the subsidy prohibition, show similar gaps in their subsidy definition. This sentence doesn't make sense. Anyway, you know what I mean. If you look at the EU, the state aid test may be too lax in terms of that it allows a circumvention of the state aid prohibition via implementing legal financing obligations. It may be too harsh because of this Dutch trading emission scheme. So maybe it is too harsh to include the trading emission scheme or treat it as state resources just because the certificates are not attached to a product, but they're a product by themselves. And maybe because it is partially too lax, partially too harsh, maybe that delineation between state and private action is in itself distortive of competition or negatively affecting the trade between member states. So I would suggest there are economically unsound results due to a formalistic instead of effect-based assessment criteria, and the formalistic criteria that the EU introduces in its test is, or in its legal regime, is the double criterion test. So that's a formalistic island in the otherwise functionalist approach. I can jump over this. So this is the initiation of my conclusions. We're nearing the end, which is good. I've shown you that, you've seen that some markets cannot do without subsidy control. I would suggest that those are only transnational markets. You've seen that. But if you initiate subsidy control and not opt for another regime, alternatives are available. That's something that I've said in the introduction. Of course, you should take care that the right measures are caught. Under a WTO regime, there is a risk of under-enforcement because the definition is not proper and you have an enforcement deficit, but maybe, and maybe we can discuss this afterwards, maybe that's just what the WTO wants. So I would not suggest to alter anything here. If you look at the EU, I've just said there's a risk of under as well as of over-enforcement, depending on the type of situation that you're looking at. If you couple that with a very effective enforcement mechanism, the distortive effect of those flaws may be significant, and the distortive effect comes from flaws in the functional definition that the EU applies. I think in spite of the flaws that the functional approach of the EU shows, there is a general preference for that approach over the WTO's formalistic approach, of course, because the functional approach is more flexible, it is more easily adjustable to the competitive environment, but it should be balanced out. Obviously, balancing out would mean abandon the double the double condition criterion. I think that proof of the public initiative should be sufficient. And if you examine actually the scenarios more closely for which that double criterion test, I think, was developed, so the minimum pricing schemes, you will find that doing away with the public resource criterion, so not demanding control over the resources anymore, will not harm classic minimum pricing schemes where the customers are not locked in. Those schemes will not involve aid, so there will be no change under an adapted regime. It will only touch such regimes where the customers are locked in, and then maybe it is also warranted for the Commission to look at a minimum price regime with a lock-in of customers. But those won't be many cases, and maybe the competitive effects of those cases should be checked. With that, I'm at the end of my presentation. I hope you didn't fall asleep entirely. Thank you very much.
Thank you very much, Professor Jaeger. It was a very interesting lecture about the EU state law. And now I invite Mr. Professor Alessandro Octaviani, professor at the University of Mackenzie and São Paulo University, and also CADE's commissioner. Professor Octaviani.
I have I think here 8 points to share with you about what we've just finished to about the presentation that we just saw just now. These these reflections will start from the functional approach that Professor Thomas tried to develop in his presentation. These 8 points are, first one, I think we should came from the realistic political economy, and I think here we are talking about Hamilton and Friedrich List, namely. The second point is this political economy, it came into the competition policy that we have here in Brazil. We have a lot of principles that can prove this point of view. Third point that I want to share with you, the question of state aid. I think it's the deep soul of the capitalism, and we, as authority, we should be we should have very deep attention to this kind of questions. The fourth point, I think we have a very important example about this kind of subsidies and this kind of state intervention in the world financial crisis. I think it's a very important and a very lighting point to understand what we are talking about. The 5 point, I think I had 7 observations about the lecture that we've just seen before. 7 or 8 points about your very interesting presentation. And namely, I think it's an important point to think about an antitrust policy in the semi-peripheral economies. Is it the same policy or a different policy? We have to think about this kind of point. Another point, the state aid here in the semi-peripheral economies, it helps to build competition. I think we have to understand these kind of things. And finally, a kind of conclusion. I don't know if I will be able to arrive in any kind of conclusion, but I'm going to try. So the first point came in from a functional approach. I think we have a kind of specific political economy that help us to understand what we are talking about in a not so normative way, but in a more realistic way. I think it must be the way that we should be close to our subject. This realistic political economy, it's not an invention of some heterodox economists from the periphery of the capitalism. No, it's an invention of Alexander Hamilton, for example. He is the first General Secretary of Treasury in US. Okay, the report on manufacturers and the report on public credit are reports that just say one thing: the economy develops with some specific rules that brings the competition between center economies and peripheral economies. And as US were at that time a peripheral economy, they would be very realistic in this kind of competition, and how would they protect the economy in this competition, this international competition. After, I think probably a lots of years after, for example, Immanuel Wallerstein developed a formal scheme that could explain this kind of competition, and he developed the scheme: center economy, peripheral economies, and semi-peripheral economies. Okay, it's just a developing of a pragmatical approach that US always had in their political economy. All right, it's not just North American invention. We have a very great example in Germany as well. Friedrich List, for example, he visited US and he saw the Hamiltonian experience in what it was creating in America, and he developed a lot of a very important framework to think about the competition against England. That was the point, the main point that was in the thought of Friedrich List. So it's both Hamiltonian and Listian approach. I think they are working in a functional approach, and they allow us to understand how the economy really functions. And it's not just a question of theory or a question of politics. it's inside our laws, inside of our decisions, and namely when we are talking about the control of economic power. So, am I talking too fast? No? Okay. All right. Second point. Here in our competition law here in Brazil, and as well in lots of another laws in foreign countries as well. Sorry. We have lots of these principles of a realistic political economy inside our patterns of decisions. So we cannot just think about patterns of contracts between companies to understand the real relation between the companies. So we need to understand the real power that is involved in that relation. So that's why our law allow us to decide with some other criteria that go far away from just formal criteria. Okay, as used to say Max Weber, power is the capacity of impose behavior in another person, independently of the will of this person. So we need to be able to understand how the economic power is able to impose a situation in another person that is in that economic relation. It brings us very far away from any kind of formal approach. We need to use here in our area of reflection and our area of action. We need to use the functional approach, and we need to be very close to a realistic political economy. So the third point, the state aid needs to be seen from this point of view, the realistic political economy. And I don't have any doubt to say the state aid is the very soul of capitalism. We have this kind of history in England, we have this kind of history in United States, we have this kind of history in Germany, in Japan, in China today. So we don't have to be we don't need to be ashamed to say, as Fernand Braudel used to say, the state is the capitalism. The center economies always used the state to build their economic powers. It's a question of history. It's not a question of ideology. All right. So if we start to say, oh, this is a kind of question that just lives in the past, we just have to remember that in the contemporary financial crisis, the public money, the state-owned money, bring us to the financial market $7 trillion to say we are here to build the system, the economic system. We are here to maintain the economic system. The state is the economic system. So we need to have this framework to be close to the question of the state aid and the question of it's because it's a rule of the real functioning of the economy. So now, with this framework that I've just built here with you, I will try to be close to the very important and very interesting lecture that were just made for us. I've reserved, or I selected here 7 points that can help us to understand from a point of view, from a semi-peripheral point of view. The first one, a very important declaration here, or a very important quotation. First one, of course, we have subsidies. It's a very important point that just opened the lecture. It's a very lighting point for us. So there is no question about if the real economy works with subsidies. Okay, just a very strong ideological approach can talk about no subsidies in the real economy. So that's why the phrase was a very strong and very important phrase. Of course, we have subsidies. So the second point that was very important for me, shall we control this kind of subsidies? So how can it be controlled if it's interesting to be controlled? Because sometimes there is a kind of discourse and another kind of practice. So it's another point that is very important to be in our minds when we are trying to understand this kind of behavior in the real economy. So the third point that I want to bring us to our reflection is another phrase that were here. The general rule in US, no subsidy control. So there are exceptions, but the general rule, I think it was very clear. And it's not, it's a normal thing. It's the right thing to do if US want to be the economy that they are. They have this practice, they have this history, and they have this they have this contemporary history. So there is no surprise. Okay. The fourth point that I want to bring here, the WTO definition for subsidies. The 50 point was from that point that were mandatory in a selective manner. Okay, so how does the subsidies act in the economy now that the countries that US and namely the countries that are in WTO, that rules the WTO, how do they act in the question of subsidies? In a selective manner, because there are a lot of industries, a lot of markets that they had developed. So now they can act in a selective manner, okay? And the examples, for example, the green tax and all the discussion on the subsidies in technological innovation. I've been in Sweden for a lot of months, just studying how did they build the next round of the international competition on technological innovation. So the subsidies now, they can have this approach in a selective manner because a lot of tasks are just finished. So it's an important point for me. And the other point, complex forms of regulatory intervention may escape subsidy control. That's so in a selective manner, they choose what they will subsidize, and in another point, they have a lot of complex forms of intervention, so complex forms of subsidies that are just out of this control. So, for example, if we can interpret or we can read the subsidies to the financial market as a form of control that's completely out of this kind of formal approach to the question. So that's why we need to have a realistic approach about this question, because if we have a formal one, we are not being able to understand the reality, and we are just talking about formal schemes or neoclassical schemes or normative schemes, and we are not being able to understand the reality. And that's what matters for a country like us and for all countries that are represented here, to understand the real economy, to understand the effects of economic power in the lives of the people. So the last point here, state can escape the aid prohibition without assuming control over the resources. So it's another point that brings this kind of very dynamic form of acting in the field of the subsidies without any control. So we have a formal approach, but we have a lot of things happening that are just out from this approach. So these are the points that we need to pay more attention, because in these invisible places of the practice of subsidies are the most important practice of subsidies. That's my point of view. So these are, I think, the most important points in the lecture that I could see. These are just suggestions, actually. I know that every one of you could see a lot of different things here in the presentations, and including much more interesting points of view that I'm bringing to us. Every organization of a text is a choice from a specific point of view, a political point of view, a sociological point of view. So I'm sure that you have yours, and I will be very happy to listen to different reconstructions of the lecture that we just seen. Well, coming from my three last points, I think that in the semi-peripheral economies, and that's for me what Brazil is today. We are not in the center. We are not in total the periphery of the system. We are in that middle that Giovanni Arrighi, Emanuel Wallerstein, and so on, they call semi-peripheral economies. Here, the state aid, the subsidies, the state-owned companies, the state-owned banks, they are responsible for the building of the market. They are responsible for the building of the industry. So this is a point that we are just copying the countries of the center, but we are trying to learn. We are not so good because we are our companies are not so powerful, and our military arm are not so powerful. But we are trying in the last decades to build some specific industries in some specific fields. That professor that was just that recently. Professor Amsden, the ascension of the rest. It's a very important title from her. She tries to understand how the rest, we are the rest. We, China, Mexico, and Singapore, a lot of countries like this, we are the rest. She tries to map how the rest are trying to use things that were used before, and how we, and inside this kind of tools, there are the subsidies. So here, this is the point. The state aid are being used to build the market and to build the control, and including, and this is the almost the last point, the state aid is being used to build competition. So I have here kind of systematization of the news just from the last week. It's in Portuguese. I will try to make a translation. Certainly it will not be so good, but I'm going to try. Montadoras, the automobile industry, all right, are demanding to the government that the banks are making so hard the credit to their to their activities, okay? And then, as a response, not just for this demand, but for a lot of demand, we have this another news. The state-owned banks, they are cutting the tax of interest. Is it correct? Tax of interest, okay? The level of the interest that they charge from their clients. So, and because they are being forced by the government to make low their interest rate, their interest how could they say tax rates? Yeah, because they are trying to they are being forced to by the government, they are being forced to lose their money. The private banks are being forced to reduce their rates. So we are just seeing here this week an example of how in a semi-peripheral economy the state can build industries and simultaneously can build the level of competition. So we could here discuss the the causes of the interest rate here in Brazil and their level. We should discuss the Plano Real, real plan, causes and their its political economy. It will not be possible. But here we are with a consequence and with an application of a functional approach to a specific economy, the Brazilian, a semi-peripheral economy. So it's an example, a practical example about the question of subsidies, not in a central experience, but in a semi-peripheral experience. So this was my intervention. Thank you very much for the attention. I know that I've talked too very fast. I'm here to listen to you all. Thank you very much. Professor, we are, as Brazilians, deeply honored to have you here. Thank you very much. Thank you.
Berg for American Antitrust Institute. I'm particularly interested in the relationship between the Commerce Clause in the United States that you mentioned and the state aids jurisdiction in the European Union, and then in other countries that don't have either one and have the central peripheral relationship. This is fascinating stuff, and I talked in an intervention yesterday about how competition among governments is one of the shaping factors for competition policy. Well, here we have something very interesting going on that let me mention. In the financial crisis in Europe, Neelie Kroes, the director, the commissioner with the portfolio for competition policy, also had state aids. And what that meant was, in effect, that competition policy was very much in the center of the resolution, the approaches taken by Europe to the financial crisis. Compare that to the United States. Lacking a state aids jurisdiction, in effect, nobody representing the competition idea was at the table. What did we get? We got overnight mergers that made sense to the bankers, made sense to the Treasury Department, made sense to the Federal Reserve, but it resulted in an increased concentration of banking resources in the United States that was virtually uncontested, virtually not discussed. It just happened because there was nobody speaking for competition. And that was not an oversight. The Treasury Department, Federal Reserve didn't want the Justice Department to participate. What would it have done? It would have slowed things down and decisions had to be made quickly. But it also would have raised uncomfortable questions about policy. So I think that the United States, at least now has to go back and make some comparisons between how successful the interventions were in Europe as compared to the United States. And we're going to have to rethink whether we need something like a state aids program or maybe some kind of a law that introduces a competition mission into the next crisis, which will surely occur sooner or later. But these are, it seems to me, these are basically events that weren't predicted. They weren't part of the European thinking about how are we going to deal with integration of a market, because they weren't thinking in terms of financial crises any more than they were thinking in terms of financial crises affecting the euro or the euro affecting everything else. These things come along, and the institutions that happen to be in existence are the ones that are going to be utilized in a crisis. And it's just fascinating to see this interplay between competition laws, competition policy, and other political, economic institutions. I thought that both of you were presenting fascinating approaches to looking at what's going on. I just wanted to add the financial crisis and its potential implications.
I'm not sure if I understood the relevance of that, so if you can explain that, that would be great. And my second question is, the creation of tradable property rights constitutes, by law, constitutes state aid. That's how I understand what the ECJ decided in the Dutch case, right? Has anyone argued that intellectual property rights are state aid? And the last question is, for you is, so under your proposed definition of state aid, do you think the German law in Preußen Electra was state aid? And yeah, that's all the questions I have.
I'll start with the financial crisis first. Just a very brief observation. I think I'm not sure whether the handling of the financial crisis, so the handing out of funds to banks is dealt with better if you have a state aid regime in place, because some have argued there is the competitive effects, in spite of the huge amounts that were handed out, although basically most of it in guarantee, so it wasn't actually paid out, but still huge amounts that we're talking about, had very little competitive effect because it was handed out homogeneously in the whole sector. So that limited the effect. What was in fact problematic, and the Commission tried to control this, was the cannibalization effect resulting from that. So preventing or capping the aid that was handed out to the better off banks, to the extent that they would not cannibalize the market, buy up the weak banks and improve their competitive position. But for that, of course, I think that's something that you can easily tackle with merger rules. So that was one of the main concerns, and now the Commission is trying to extract the amounts that were handed out from the economy again, but that's more of a post-development. So to sum up this first point, I wonder whether the European case is really an example for the U.S. It's a very different setting, and I would assume that U.S. antitrust rules would suffice to at least tackle the most extreme effects of the aids that were handed out to the banks, even though competition people were not present at the table. Now, for the Commerce Clause, as I understand it, and many of the U.S. cases that I've heard of concern taxes, state taxes. That's a very fashionable way of attracting industries to regions in the U.S. And the way I understand it is that if the tax has an effect on interstate trade, the Commerce Clause applies, and that tax is caught by the federal competence. So it's, in fact, and this brings me also to a more general point, in fact, in intra-state settings, so within the state, even if the state is federalist, like my own in Austria, we have the same problem of subsidies handed out by the states and by the federal government, sometimes in parallel. The question whether you really have a problem is how watertight is your horizontal distribution or actually the vertical, in this case, the vertical distribution of competences, so between the states and the federal state. If it's clear what the states or the provinces are competent for, if it's clear what the federal government is competent for, then you do not have a rivalry situation. Of course, I understand that in the U.S. this works quite well. I'm not sure. Maybe you have other examples. In Austria, the vertical distribution is not excellent in the sense that parallel subsidies are possible as long as they're versed by private means, so not as part of the public power. It's not based on a law that the province is entitled to enforce, but as a private by, for example, contract means or so forth. Then you can have parallel subsidies, and there is indeed a rivalry in Austria. I wonder whether that's also the case in the U.S. Then for your questions, the first one was about the lock-in. I didn't mean to say this should be an element of the state aid definition. What I wanted to say was that this double criterion, so the idea that you have to check not only where does the initiative to subsidize come from, but also in addition make sure that the means have been somehow controlled by the state. This overly formalistic, I don't know, this overly burdensome approach, if that approach is changed and you only look at the initiative, you don't look at or introduce an additional requirement as to resources, that would only be a problem if you have a minimum price system where consumers are locked in, because then, of course, they cannot escape the minimum price. And the additional amount that the company reaps from this minimum price is aid. And those situations would be caught. If the customers are not locked in, then you would assume that the market share would dwindle and there would be no aid. So it's not, I think this is a misunderstanding. I didn't propose to make that part of state aid definition. It was actually more part of showing that the effects of changing that approach would be limited. And that brings me to your third question, the price and electra question. Of course there would be aid. And I think if you look at commission practice since price and electra, and I found that very intriguing, the point that you have made that, of course, especially for new technologies, I mean, what better way is there to subsidize a new technology than to create a legal financing obligation for it? You say, this is very beneficial. Everybody needs it, so we will just comply our citizens to finance it, and other than that, we don't get involved. So I found that an extremely helpful point. And price and electra was an odd case, and the Court of Justice said, no, this is in fact, it didn't say it, but meant it. This is in fact the minimum price system for electricity. And ever since then, all the member states jumped on price and electra and said, okay, we'll do the same. Our system is also no aid, and the Commission has, I don't know, there are 20, maybe 30 cases where the Commission has always said, no, this is not the price and electra exception because that's a very specific case. So the Commission has tried to cut off this circumvention possibility, but it's had a hard time because of price and electra. And I think, of course, this is an aid case. And the question about IP rights, of course, I like that question very much. Of course not. But if you take a critical approach to overprotection under IP, maybe that question is warranted. Maybe that question makes sense. And then I have a couple of comments on your presentation. Well, maybe we'll take questions first.
Yes, Christian Rivenes from the Belgian Competition Authority in Brussels. I would like to make a comment on this comparison between the US and the EU jurisdiction, which was made by Albert Fur with that answer of Professor Jaeger. Maybe the opposition was a bit too sharp. For instance, in the case of the banking sector in the UK, there is, for instance, the case of the merger between Lloyd and TSB, where in fact the British Competition Authority, the Office of Fair Trading, was overruled by the British government. And I would like to make another comment by relying on a very recent empirical research done at the University of Brussels with Belgian data. And the main empirical result is very disturbing and warning effect of subsidies on the level of concentration, of industrial concentration. That is, it appears that within several industries which were studied, that the subsidies mainly go to the largest firms. So state aid tends to increase the asymmetry of market shares, and so it tends to increase the the level of concentration in a very significant way. And my question to Professor Jaeger is a bit the following. Do you think that there is some lack of consistency of legal standards between, on the one hand, the state aid control, and on the other hand, merger control? That is, for merger control, the European Court of Justice had a rather high legal standard. That is, it requires really an economic approach, an effect-based approach, which in a way obliges the competition authorities, especially the Commission, the DG Competition, to develop analytical skills and applying models. But it does not seem that such a requirement exists for state aid control. How would you explain this difference of legal standards?
Thank you very much. The point that you've made is very valid. I cannot but agree. I mean, I've talked about the attempts of the Commission to introduce a more economic approach also in state aid, but that was more or less half-hearted. And why? Because I think there's an intrinsic conflict, because state aid, and that's what also Alessandro and I tried to highlight in our presentations, who you give state aid to, what extent you hand out state aid, or to what extent you hand out state aid, that's basically a policy choice. And the EU state aid control doesn't do anything else. There is a state aid prohibition, but of course there are reasons for justification. If you're in line with the policy choice, it's fine. And that's also something that I wanted to add to your presentation. You also see this schizophrenic approach between or in the EU, because state aid control within the EU is very tight, but as soon as you talk about the external dimension of subsidizing exports or what have you, I mean, of course, the Commission is very happy to have subsidies. So it's a policy instrument, and we should see that. And that brings me back to your question. So why didn't the more economic approach work, or depending on who you ask, but why is the scope of application limited in state aid? Because, I mean, more than other areas, state aid is not accessible to efficiency control. There are other, I mean, depending on how you define efficiency, you may have distributive efficiency, but you will always end up with the problem that, for example, to justify environmental aid, which is obviously under policy perspective very useful, under an efficiency perspective, you will have to, I don't know, calculate external effects and so forth to eventually arrive at an economic answer that will tell you, okay, handing out this aid is efficient. So it doesn't work. It's it was, I think, a flawed exercise from the beginning. And that shows, as you rightly say, in the Commission's and the ECJ's approach to those two latter requirements that you have in Article 107, so the distortive effects and the effect on the trade between member states, because essentially the ECJ does not check that at all. It's a very low threshold test, nothing to do with economic standards. The ECJ will almost always, except in very, very rare cases, say the economic distortive effect, which is in fact the core of state aid control. That's where state aid, the whole idea of state aid control comes from, and the ECJ does basically not check it. Says, okay, fine, we assume it's fulfilled, and jumps on the other conditions. So that's a problem, but the problem comes from the policy background. And is there? And then I'll stop. I'm talking for too long. Is there inconsistency between state aid and merger? Therefore, procedurally, no, because that's especially what you see in the context of a financial crisis. The Commission takes care to procedurally, for example, in the merger case. Take account of the fact that state aid was handed out and vice versa. So procedurally, the competition, the communication between the different branches of the Commission work quite well. But legally, of course, there is a huge discrepancy. Yes, and I do not see any tendency, in spite of the more economic approach, of that discrepancy going away. And I wonder how you could do it. I mean, Thank you.
Dear friends, over these 3 days, we have had the opportunity to debate competition law with academics and authorities that could offer their unique contribution, illustrating that while the world is globalized, each country has its own characteristics. This exchange of knowledge and experience has been so rich as we have been able to learn from other cultures and also to offer our perspectives about the best practices in competition law and how state-initiated restraints of competition may be positive or negative. Once again, I have to thank the Ascola board for allowing Mackenzie to hold this unique conference, especially Josef Drexl, who was very receptive when I brought up this possibility during the International Competition Network conference last year in The Hague. But to make this all possible, we needed the assistance of the law school, and my thanks to Professors Claudio Nor and Fabiano, the secretariats Luzinete, Marcia, Ronaldo, Rosana, and Renato. From the university, my thanks to Sara and Luciana. From Ascola, a special thanks to Delia and Rupert. And from the Mackenzie Competition Law Studying Group, my special thanks to Tatiana, and to Amanda, Patricia, Mariana, Maria Fernanda, Paulo, Ana Cláudia, and Israel. But I have a special appreciation to all of you who have come from far and wide. Whether you have come from other parts of Brazil or crossed oceans and borders to be here, I would like to offer my deepest thanks. Next year, Ascola Conference will be held in Lecce, Italy. So allow me to conclude my farewell speech as Italians do, in bocca lupo, meaning good luck.
To say the very last words as the chair of our society, we greatly enjoyed the hospitality here at Mackenzie. It was great fun, if I may say so. It was intellectually very challenging. I found that our program was very promising, but you never know what will be the outcome. And my feeling is I am not able to summarize it, simply because it was so rich. And I think this is one of the big advantages that we, as Ascola, contribute to the competition world, that our network actually can bring together many academics from different jurisdictions that have very different perceptions and can also inform us on the specific problems that they have to face at home. And this is not something that another network like ICN can provide us for many, many reasons. And especially on the topic of state-initiated restraints, we have gone far beyond what competition agencies are doing, not just with regard to state aid, which we have covered today, or government procurement, which was covered from an Indian perspective yesterday. Also, we heard from Venezuela that competition policy can be in certain jurisdictions be an endangered species. And that we really have to fight for promoting that idea. And I would like to come back to some of the very first words and ideas that were expressed at that conference. If we ask ourselves whether competition law has to deal with values, we probably can give a very easy answer. Yes, it has to do a lot with values, especially regarding the talk we had from Venezuela. I think we are very, very close to constitutional values, to economic freedom, and competition law and competition policy can contribute a lot to this. Sometimes it's considered to be very old-fashioned, especially in Europe, because the Germans always talk about constitutional values and competition law. It's no longer modern, but I think this conference has also been a reminder that it has to be promoted again, and especially I think academics are very well suited and better trained maybe to hold up such particular values. Of course, It was kind of a difficult decision. You know it, and many of our members know it, to come here, mostly because you had to jump in. That was a difficult decision also for you. And you did it on very, very short notice. So my thanks especially go to you and to all your helping hands you had here. I have been now the chair for many years, actually, 9 years now. And I have cooperated with many of our colleagues who organized conferences. And I have to say, I was amazed that you were practically the person who was in charge of everything. That was my impression, because all the information went to your email addresses. So it seemed that nobody else was there. I think it was the first time that there was no secretary that would collect the registrations. It was you. So you did a great job. And in addition, you put on your shoulders many additional not obligations, but tasks, like making Ascola known to ICN. We managed to have the conference program and the information on the website of the ICN. That, I think, is a big value. That was not given, that we would be able to do this. You advertised the conference around South America, which actually resulted in having 2 additional speakers and commentators from other South American countries, and I think that was a very highly valued and appreciated additional asset of this conference. So thank you very much for everything you did. You mentioned next year we will be in Lecce. It will be a very, very different environment. It's still a Latin environment, if I may call it so. It's a Latin environment, but a different environment. It's a very, very small city. Sao Paulo is a very, very big city. This will create a very different environment, but the topic will be very close to what we have covered during those 3 days here in Sao Paulo. The topic will be competition law as regulation. We talked a lot about regulation during those 3 days here, but we didn't really focus on what competition agencies are doing. And our intention is to look more closely maybe at the remedies and also at the cases that competition agencies have to cover nowadays and have to try to protect competition law in very specific markets of maybe more modern style markets. And this certainly will bring more insight, and it's, I think, it really fits together with what we have done here, and we will certainly dig deeper. But thanks to you, Vicente, as I learned how to pronounce your name, and all your effort for putting up this program. I think it was a good start and a good introduction to what we intend to do next year, and hopefully we will see many of the participants here in Sao Paulo, also in Lecce, and it would be very welcome to have South Americans in Lecce. And again, I would like to address also the audience. I was very happy that we had many students here. I think it's also a good training experience to listen to law professors from around the world, and maybe also get some ideas about what is competition policy in other political settings, especially, be it China or be it India or be it the European Union. And of course, hopefully we enhanced your interest in competition policy and competition law. And I also hope that we enhanced the interests of our colleagues to be here in South America to become members of Ascola. And if you want to become a member, please contact me or also Vicente. And we will be happy, especially to accept the speakers, I guess. The presentations were excellent, very, very informative. I can only say that I'm extremely happy about the quality that we had. And the next step, of course, will be the publication of the book. I should also mention this project. So the work is not over, and it's still work for Vicente and maybe me. Edward has agreed to publish the volume in English, and Vicente has expressed his intention to have a Portuguese translation. And we will figure out, I guess, who will be the publisher. Maybe you have already identified it. And we will have to hurry up to get the book published. And this is, again, also a message to the speakers and the commentators. Of course, we would also like to have the written contributions in the foreseeable future. We will think how quick we can go ahead. The organizers of the last two conferences were very, very quick, I have to say, in getting their books published. So we will send you an information, another email, and tell you how when you should submit your final paper, but it should be in the near future before the European summer break, or before you actually have snow in Sao Paulo, which might never happen, I guess. So I conclude here. Thank you again. I have the feeling we found many friends here in Sao Paulo, I have to say. And hopefully many of us will be able to come back at one point. It's very important also, Ascola is mostly a European, I don't want to exclude the US Americans, but Ascola is mostly a European society, and it has become a worldwide society, and it establishes a close link between colleagues across the continents. And we always know that South America has a European heritage on which we can build, and that's also what we have done here to make. And basically, competition lawyers always have a tendency to work for a better world, and I think we have contributed to this endeavor, which is basically the endeavor of all of us. So thank you very much. I wish you a good trip home. Some of you will go to Rio. And I hope to see you soon, and maybe it will be in Lecce. Thank you very much.